speakers would speak on that point, but I thought I'd just sort of just make some preliminary comments that India has, if one goes by a legal origin theory, which of course has not had so many people looking at constitutional developments from a legal origin point of view. Legal origin has had great influence in economic developments. But if we look at India, it sort of seems to have moved in the last 10 years from one extreme of judicial appointments to a judicial council and a much more civil law kind of a model. And it's interesting for those of us who are from India to see the gradual reduction of an Anglo-Saxon model and an increase of a more civil law model. And given the fact that India is in this interesting space and time, it's interesting to see how exactly different developments in the world are affecting this constitutional development. And we've had like so many decades of looking at the Eurocentrism rather than an Anglo-Saxon model. So I hope we will have also discussion on that. So I think Professor Shetrit on legitimacy and constitutionality of methods of judicial.
Yes, thank you very much for the introduction. We're going to hear many arguments and analysis on judicial independence. I first want to thank the organizers for very kind hospitality and for an excellent academic program, including scarves with the personal naming, which is really a unique effort to personalize the gift, and that shows that the extent of personal attention that was paid to the minute details of preparing a name scarf. We already started the discussion, and we will be somewhat overlapping between each other during the discussion, but each one is giving his prophecy in his own language, in his own style, and according to his experience. So I will bring to you the experience, but I think I need, where is the computer man? He is not here. I want to just click on the website of the International Association of Judicial Independence, because it will help me give you in 2 minutes some background on the work of this organization, which is devoted to judicial independence. The work of the group began right here in New Delhi when we approved the New Delhi Code of Minimum Standards of Judicial Independence. That was in 1982. The work took 3 years, between 79 and 82. Doesn't succeed, Surya? And since then, we've been working now for almost 40 years. That shows that I'm not so young, even though I look young. I hope so. And so a few years later, we had a meeting in Montreal Declaration of the Independence of Justice. And then we cooperated with many organizations, mainly the International Association of Procedural Law, over the years, working on judicial independence, and Association of Comparative Law. And in 2007, we decided to revise the New Delhi Code and the Montreal Declaration, and to establish what we call, according to the location. You know, all the documents are according to the location. Mount Scopus standards, Mount Scopus international standards of judicial independence. So you have to click the link.
I can see the website here.
Ah, the connection is not correct. Okay. So what I want to tell you is that there is a website. Just copy this website, jiwp.org. Yeah, exactly. And here you have treasures of materials, standards, a reference to books, the books that were published by myself, by other members of the group. So in this 20 minutes, I will only touch like the iceberg of the issue. And okay, if you can just press projects, click projects, and then Mount Scopus. Yeah, click Mount Scopus. So here we have, in fact, already 16 conferences of this organization, either 2 or 1 every year. You name a city, we were there, not in South America, unfortunately, but we were in Hong Kong, we were in London, we were in Vienna, we were in many places. These are the publications, by now 4 volumes on judicial independence. So what I will tell you in 20 minutes is just analysis of the theories and my take or my approach and view to the Indian controversy. This is what I will do. But in order to do it, I will have to travel with you through this theoretical, intellectual excursion. And so we will start. Now we can go back to my presentation. We'll start with the values of the democratic system, because we consider judicial independence a central foundation of democracy. In a country when there is no judicial independence, democracy is deficient. And therefore, it is important to begin by, now I can handle it. I don't, yes, of course, I am very digital. When I was 19, I already in the army used computers. Could you imagine? When I was 19. The Israeli army, as you know, today is very, very highly, but we started it a long time ago when the computer was as big as this room. And the capacity was like a palm, but that was the time. So I'm digital. So, well, just very briefly, what do we expect from a democratic government? What are the values that are underlying the democratic system? And I will just, by a telegraphic way, first of all, it has to be representative. And when you say representative, you can have a whole seminar or a whole year discussing what is representative, which election system you should prefer. Proportional system, yes or no? Regional, one district representation. What is the percentage of excess in the election? 1%, 5%, 10%? What does it do in terms of representativeness? Stability. We don't want the government to change every year or every 2 years. We have to create a context of rules of democracy that will ensure stability. Thirdly, we don't have to have the parliament or the legislative body splintered in splinters. We want to have some, let's say, anchors of political power and legitimacy to run the country. And therefore, governability is a major value that we have to look at. And we have to have an efficient government. That means maximizing the resources, and the government has to be accountable. legal accountability, public accountability, all forms of accountability, ethical accountability, and so on. So these are the main basic values that I see in the democratic system. We, in the association, we decided to adopt indicators of democracy. Why did we decide it now, in the year of 2018 in London? You heard from the presentation of Kim what is happening in Hungary, in Poland, in Romania, in Turkey, and so on. And we thought it's very important to register in a very detailed way what are the indicators of democracy? How do we judge if there is a democracy or not? And these are the main points that we agreed to establish. You can look it up in the website. London resolutions have all the details. And now we go to the basic values of the justice system. Judicial independence is only one of the basic values of the justice system. And we have to look at the justice system in a wider way, in a more comprehensive way than we have to look. And there are sometimes contradictions, tensions, conflicts between the various values. So we have judicial independence, quality of justice and fairness, efficiency, accessibility, public confidence, and constitutional protection, or constitutionalism. And each one has its components, and you might think that efficiency could be interfering in judicial independence. If you lay down certain requirements from judges, it could be at the expense either of quality of justice or at the expense of judicial independence. We don't have time to dwell on that, but keep it in mind. This is where this puzzle of values that the judicial independence is placed. It's not separate. It is part of the justice system in general. Now, in addition to the values that we just saw, accountability is a very important principle that has to be, and it is very relevant to our discussion, that you have to have accountability of all public officers, whether it is judges, whether it is legislature, whether the executive branch officers, all of them have to be accountable. And another very important principle, which relates to democracy, is that the judiciary has to be reflective of the society. Why do I use reflective and not representative? Where I think, okay, never mind. At the bottom of this slide, there is a reference to this issue. The difference between representative and reflective. For the political branches, we expect representative. One man, one vote, and the representative remains committed and in contact with his constituency. After his election, not only before, after. With the judge, we don't expect him to be committed to the constituency that he is supposed to reflect. Black or purple, yellow or red, whatever, without mentioning specific domestic jurisdictions, but all the colors and all the shades of ideology, geography, and so on have to be reflected on the court. Because you cannot say, listen, there is a group of people, but they don't have a judge on the court. That's not an argument. But the general composition has to be reflective. Judges sever their commitments to the constituency from a practical point of view and also conceptual point of view once they are appointed. That's why anyone who uses representative terminology is in conflict with the right doctrine of what we expect from the judges. Now, when you ask yourself, what are the components of constitutional protection? First of all, it has to be in a constitution at a constitutional level, not at the legislative level. When we were talking over coffee, Mr. Bello, who gave the lecture, when I said that in certain situations, when in crisis time, the rules don't work, like Yeltsin closing down the Constitutional Court, he said, but President Roosevelt tried to pack the courts. Of course, there is a difference between closing the court and trying to influence the composition of the court. But what's the real story in this packing the court? The real story, I didn't plan, but because of the coffee conversation. The Constitution provides the Supreme Court is a constitutional institution. But the Constitution of the United States does not provide the number of the judges of the Supreme Court, and it has gone down and up over the years. When you check this item, you can check, and you will find the Supreme Court was, in fact, in terms of the number of different composition. Why was that possible? Because you have a constitutional court, but the number is legislative. So the president could get a majority to change the number, but still it is in a different context. You have to go to the Congress, you have to pass a legislation. It's not like Yeltsin closing down. This is an emergency or crisis situation. It's not really for us to judge and say, don't do such a thing when there is a revolution or there is a collapse of the system. What we are talking about is, let's say, normal situation. For emergency situation, probably we have to deal in a different way. What are the components of constitutional protection? One, you may not strip the courts from their jurisdiction. Two, but you can do it in all different kinds. You don't strip the jurisdiction, but you can divert the cases to a different court system that you create, which is a trick like not removing the Chief Justice of Poland, but just reducing the age of retirement. That's an easy trick to get a judge out. So stripping the courts, no. Diverting cases to other courts, no. Ad hoc tribunal, no. There is difference between common law countries and civil law countries in terms of the division of labor in the courts. In many civil law countries, there is what you call predetermined plan for assigning the cases. And in the common law, it's the jurisdiction of the Chief Justice, the Chief Judge, the President, the administrative president, and so on. But this is different concepts. We will come to later to discuss what we call universality versus particularity, because you can have a certain statement about universal rules, but nevertheless, when you judge it vis-a-vis local circumstances, you have to make some kind of an exception or exemption. Post-decisional independence. What is the use if you have a judgment and it's not enforced, or it can be reversed by a simple majority? And this is quite a recurrent phenomenon. And the judges cannot be part of the administrative arm of the government. They have to be separate. And the terms of judicial office cannot be changed and applied to sitting judges. Only if you want to introduce changes, you can introduce, but for future judges. For example, the Judicial Pensions Act in England it has a clause that's called grandfather clause. Why? It was applied only, when it was first applied, it was applied only for future judges. And now, after we have examined basic values, we come to judicial independence, our good friend and our very familiar, important principle. One element is the independence of the individual judge, which includes personal independence, security of tenure, remuneration, not to be transferred without reasonable reasons, etc., etc. And for each of these problems, you find millions of examples. I'll give you one example from Portugal about remuneration. It was a case that was presented to the European Court of Justice in Luxembourg. And the question was, should overall economic measures that require reduction of salaries for the whole economy, could it apply to judges as well? And the court says yes. That means when it is an overall economic measure, the judges cannot say, listen, we are different, don't touch us. And this assumes that judges are not separate from the community. Judges cannot say that they are not to be participating in the effort of economic recovery, etc. But you can find other cases in other countries, but I just gave this example because it's recent from recent times. Now, substantive independence means, or sometimes the American terminology is decisional independence. That means when you make the decision, the individual judge has to be independent from parties, from government, etc., as we just heard. And then there is a very important concept, internal independence, which means the judge is independent vis-a-vis the internal system of the judiciary. That means the chief judge cannot tell him how to decide. It's not only the phone call that we talked about, or that was referred to in the Soviet phone call calling. It started by some statement of a judge in the European Court that says, I got a phone call from certain official. So we are talking about the independence of the judge from his fellow superior judges, and he is not subject. But then the question is, how about running the court, management, efficiency, assignment? So we have to decide what is judicial that refers to this principle, and what is just administrative, which is not covered by the internal independence. The judge can claim, this is judicial, I don't listen to you, but the judge cannot say, listen, I don't want to follow this assignment, I don't want this file, because I don't like it, or something like that, or I don't want to come at 9 o'clock, I want to come at 10:30. So this is internal. And then a very important concept that developed only in the last decades, and we helped it since the New Delhi Code and the Montreal already, collective or institutional independence of the judiciary as a whole. Not only do we expect the judge, the individual, to be independent, we also expect the judiciary as a whole to be independent. Because if the judiciary as a whole is not independent, this will reflect on the operation and the exercise of the judicial functions by the judge So here, we talked about what we call the principle of judicial independence, but here we're talking about the culture of judicial independence. The culture is not limited to the judges or the judiciary. The culture encompasses, covers also the whole system. So you need to have institutions that will preserve the jurisdiction. You have to have constitutional infrastructure that protects. And you have to have climate, political climate, because no judiciary can exist if it is not supported by the general public, by the political leaders. No country, the founding fathers of the United States were politicians. The deal between parliament, I call it a deal because that's the modern term, parliament and the king, after the Civil War in England, that established the Settlement Act of 1701. It was with the political powers. So we need the political power in the whole political system to be part of this idea that I call culture of judicial independence. So I already mentioned these rules on constitutional protection, ad hoc tribunal, diverting cases, standard judge principle for civil law country, post-decisional independence, separation of the judiciary from civil service, and prospective application of changes in terms of office. Now we come to the exact topic of my lecture here, and you see here on the screen the models of judicial appointments. Predominant executive role, general elections or combined model between elections and some other procedures, legislator elects, appointment committees of different kinds, and special case of career judiciary, which you start after law school, you go to become a small officer, lower officer like referendar in Germany or stagiaire in some other countries, and then you go on until you get to the top position based on a certain promotion. This is career judiciary. Now, predominant executive role, here you have total executive role. How I am doing? 5 minutes. It's good enough. Total executive role with some consultations. That was the case, for example, in England until 2005. The Lord Chancellor had this. Then shared responsibility, executive and legislature. You have a mistake here, URE and not TOR. It's my mistake, even though my not secretary, but assistant helped me, so my proofreading was not so good. U.S. federal courts, only for the U.S. federal courts, President nominates, Senate confirms. So this is the shared responsibility model. Then we have elections. In California, elections. In Switzerland, for the lower courts, elections. And here we have to mention two concepts. The election is for a term, but the judge is subject to recall by petitions that are signed by the general public. And it happened. Chief Justice Byrd and two other judges were removed by a recall. And then we have also a concept of retention. After the term, the first term, you stand unopposed for approval by the general election. The legislator elects in Germany, in Switzerland for the top courts, in Germany for the constitutional court, and then predominantly professional nomination commission. This is now the British model, that the judicial nomination commission or appointment commission gives the names. It's 15 members, and it gives the names. And predominant professional nomination commission also exists in Scotland and in Northern Ireland for the UK Supreme Court, which is separate from the ordinary appointments in England. In Israel, we have collegial selection committee that reflects all the branches of government, which is three Supreme Court judges, 2 members of the Bar Association, 2 members of Parliament, and we have a problem. the convention is one of the members of parliament has to be from the opposition. That's a convention. It's not written in the law. But what happens when the party to which the opposition member is a member of switches and becomes a coalition? What happens? Then we are in a situation no opposition is reflected on the committee. And the Supreme Court of Israel had to deal with this case, and it decided not to intervene. But we have to refine the system to make sure that that this type of opposition reflection or position representation, here you can use both, has to be assured. What is the definition or the classification of the Indian situation? Well, according to the collegial selection committee that was proposed and set aside in the 99th amendment, it falls within the collegial selection committee that reflects the branches of government in the sense that the two eminent jurists are elected by a reflective committee that is law minister, two judges, three judges, and two members. So this you can call also falls under this element. The special case of career judiciary we already talked, and now the situation of India you all know. We will discuss it later. And I skip this one, and I skip this one, and I come to my principle from the intellectual and doctrinal point of view of dealing with the Indian situation. What is my view as an outside observant of the Indian situation? So we saw that there are all forms of legitimate systems of judicial independence, and they are accepted all over the world as legitimate. And the system that the amendment proposed is absolutely legitimate. According to the general or universal experience, it is legitimate that the selection committee will select and not the court. Now, but nevertheless, okay, this is the universal approach. Universal theory says it is possible to have a judicial selection committee. So to say that it is a basic structure, that only the judiciary will select, it's very difficult to argue because of accountability and because of separation of powers, which is a doctrine accepted. Now how? So we have universality theory, but we also have the particularity concept. What is the particularity concept? Whenever you have a universal rule, but in certain domestic jurisdiction, there are circumstances that call for a different regulation or arrangement in that matter, you have to accept it and consider it. At least it is an open question, and you cannot say, okay, universality rule has to apply, and therefore it is wrong to accept certain practices. Now, we don't do it only in situations that a certain system makes the rules less than the rule of the universality standards. We can apply the same idea when a certain jurisdiction decides to make the rule for its own, which is stricter and higher standards for itself. And this is what happened in India. Because if you talk about exceptions in the past, the Lord Chancellor was a complete deviation from all rules that you can think of. He wore three hats: legislative, executive, and judicial. He was the head of the judiciary, member of cabinet, and Speaker of the House of Lords. Nevertheless, when we had to deal here in this New Delhi code with, and we said the judges have to be separate from the executive. Okay, what do we do with the Lord Chancellor? This was before Procolo versus Luxembourg, that the court decided not to mix judicial and legislative and executive functions. So we decided that when it is considered as long and democratic tradition, we accept it. And that's what we wrote as the qualification to the rule. That was for the Lord Chancellor. We didn't need to do it in the Mount Scopus of 2007 already. We left it without qualification because the Lord Chancellor already separated from his judicial functions. What about the political activities of judges? In Europe, it is accepted. So we had to deal what to do. So we decided that in the New Delhi and later standards, a judge cannot hold office in a party. That means he can be a member, but he cannot hold office, like being a secretary or chairman of a branch, etc. And finally, to talk about exception situations, look at what is happening in France, Italy, and Belgium as an example. In France, the Conseil Constitutionnel, Bernard could tell us a little bit about it, it has a very strange composition. It is the top judicial constitutional institution. It has 3 from each of the branches. They are appointing three judges, and the former presidents. This composition, is it free from politics? Is it free from our way? But okay, we accept it. Why? This is a long and democratic tradition. And Italy does not define its top court as a judicial body, but as a constitutional organ. Again, the same idea. And finally, Belgium had to deal with the question, what happens when 3 judges from one side of the house, because it's balanced between Flemish and Wallonie communities, and 3 judges took part in the legislation when they were politicians. Then they were elected to the top court, and then they had to deal with the constitutionality of this piece of legislation. And the court has to decide what to do. And the court decided they cannot disqualify these judges. Why? It will create imbalance between the 2 sectors that are the reflective or representative, but here is representative of the communities, and therefore they decided that they don't have to disqualify. So, what is the conclusion from those examples? That particularity has to be recognized and has to be accepted as an exception, and nevertheless, in spite of the fact that universality rules are going to the other direction. So what about the Indian situation? Can we define it and recognize it as a particularity, so for it to be recognized as legitimate in spite of the fact that by all accounts and by all analysis, it is really not consistent with the thinking of almost all the world attitudes in this regard. So my view is that it does, that the special circumstances of India in the last 30 years, extending to the emergency periods and extending to some crisis, may justify the recognition that these circumstances are particular, and therefore that it is legitimate, and therefore, according to the title of my presentation, the legitimacy of methods of judicial independence. So in spite of its uniqueness and exceptionality, I would say it is possible to define it as a legitimate system, in spite of the fact that by universality analysis, it is not. Thank you.